Please be seated. I declare open the public hearing on the merits in the case of Sargsyan against Azerbaijan. The application was lodged with the court on the 11th of August 2006 under Article 34 of the Convention by an Armenian national, Mr. Mina Sargsyan. It was allocated to the first section of the court pursuant to Rule 52, Paragraph 1 of the Rules of Court and communicated to the government on the 5th of July 2007. On the 11th of March 2010, the Chamber decided to relinquish jurisdiction in favor of the Grand Chamber, none of the parties having objected to this relinquishment. The application was declared admissible by the Grand Chamber on the 14th of December 2011. The respondent government are represented by their agent, Mr. Shingis Asgarov, assisted by Professor Malcolm Shaw, QC, and Mr. Gabriel Lansky, counsel, and by Mr. Otarik Valtze, Professor Hannes Tretter, Mrs. Tatiana Urdaneta Vitek, Mr. Orkan Ismailov, Ms. Jana Messerschmidt, and Mr. Galandar Bagirov, advisors. The applicant is represented by Mr. Philip Leach, Ms. Narine Gasparian, and Mr. Vahe Grigorian, counsel, assisted by Ms. Kanik Ohanyan and Mr. Aman Alonian, advisors. The applicant, being of Armenian nationality, the government of Armenia have expressed their wish to take part in the written and oral proceedings as a third party. They are represented by their agent, Mr. Gevorg Kostanyan, assisted by Mr. Emil Babayan, counsel. I welcome the representatives of the parties in the name of the court. Having consulted the agents of the governments and the representatives of the applicant, I have determined the order of addresses as follows. Mr. Leach, Mrs. Narine Gasparian, and Mr. Vav Grigorian for the applicant will speak first. Then Professor Malcolm Shaw, QC, and Dr. Gabriel Lansky for the respondent government, and finally Mr. Kostanyan for the third-party government. I call Mr. Leach.
Mr. President, this case arises from the armed conflict over Nagorno-Karabakh. The original applicant, Mina Sargsyan, lived with his family in the village of Gulistan, an ethnic Armenian village situated within the territory of Azerbaijan. On 12th and 13th June 1992, the village came under attack by Azerbaijani armed forces, and as a result, Minas and his wife Lena and all the other villagers were forcibly expelled and fled into the surrounding forest in fear of their lives. Mr. and Mrs. Sargsyan resettled in Armenia. Mina Sargsyan died in 2009 at the age of 79, and Lena died last month, aged 78. This case is continued by their son and daughter. I will respond to the court's first question as to the family's claim under Article 1 of Protocol 1 and Article 8 in relation to their home, land and other property. Ms. Gasparian will then make submissions about the family's graves under Article 8, as well as responding to the court's second question on Article 13, and then Mr. Grigorian will respond to the court's third question on Article 14, and will make submissions on Article 41. Mr. President, the Sargsyan family were forced to abandon their home, their land and other property, and they've never been able to return to the village. The denial of their right to return to Gulistan and to have access to and to be able to use and enjoy their property or to be compensated amounts to a continuing violation of Article 1 of Protocol 1. The government argues that it lacks jurisdiction and has no responsibility for this case. They accept that Gulistan was and remains within its internationally recognised territory. There is therefore a presumption of jurisdiction. This presumption can exceptionally be rebutted. We submit that the government has failed to adduce sufficient evidence to rebut the presumption of jurisdiction for the period from 15th April 2002 to the present day. Azerbaijan's pleaded position has been inconsistent and unclear, but in 2012 it accepted that Gulistan was not under Armenian control. Its evidence is weak and unreliable. For example, the March 2012 statements of Lieutenant Colonels Abbasov and Husseinov have substantial passages which are identical. The intervening government's position is that the village has always been under the full, effective and overall control of Azerbaijan and relies on detailed eyewitness statements from Nagorno-Karabakh officers attesting to the presence of Azerbaijani military positions in the village. Several statements from former villagers who have tried unsuccessfully to go back to the village confirm that Nagorno-Karabakh forces were not in control of the village. Now, if, contrary to our submission, the court were to accept that Azerbaijan lacked control over the village, its responsibility is nevertheless engaged, as a result of its positive obligations under Article 1, to take appropriate steps to ensure respect for the Convention rights within its territory. Those obligations remain even where the exercise of the state's authority is limited in part of its territory, so that it has a duty to take all the appropriate measures which it is within its power to take. Therefore, even in the absence of effective control over Gulistan, the government still has a positive obligation to take diplomatic, economic. Therefore, even in the absence of effective control over Gulistan, the government still has a positive obligation to take diplomatic, economic, judicial and other measures to secure the applicant's convention rights, as was found to be Moldova's responsibility as regards Transnistria in the Alashku case. And the court applies a high standard. In Alashku it said that the state must endeavour, with all the legal and diplomatic means available to it vis-à-vis foreign states and international organisations, to continue to guarantee convention rights. As regards the extent of the government's positive obligations, the present case is different to Alashku. In Alashku, it was established that the Transnistrian regime had de facto control over that territory. In this case, we say that the evidence establishes that no other state or entity has control over the territory. Therefore, the extent of the positive obligations on the government to uphold the convention rights in the territory of Gulistan village are greater than was the case for Moldova and Transnistria. That is because there would otherwise be a vacuum in relation to territory which, since 2002, has undeniably been within the espace juridique of the convention system, a state of affairs that the court in Cyprus and Turkey said must be avoided. Mr. President, it is abundantly clear that the government has done nothing in order to uphold the convention rights of the Sargsyans, as regards their right to return to their house and land or be compensated. Since 1993, it has been a cornerstone of the international community's efforts in seeking a resolution of the conflict that refugees and displaced persons should be granted the right to return voluntarily, or that they be provided with compensation, notably in the Bishkek Protocol itself and through the OSCE Minsk process, as reiterated in the 2005 Basic Principles and the 2007 Madrid Principles, and subsequently. The centrality of the right to return has been constantly underlined in UN Security Council resolutions by the Parliamentary Assembly of the Council of Europe and the European Parliament. The international community has also continually made clear its frustration and regret at the lack of any tangible, practical developments on this question. This court has bent over backwards to give the government the opportunity to explain what it has done in order to comply with its positive obligations. Even in response to the court's second explicit request on this point, to describe in as much detail as possible the general and individual measures taken since 2002, Azerbaijan's response is merely to submit that it is too dangerous to allow people back into Gulistan, and to refer to a 1991 order which refers to the possibility of private exchanges of property between refugees. As to the restoration of the rights of refugees like the Sargsyans, There is nothing else, not one single specific step taken since 2002. Compare that with the series of specific steps taken by Moldova in the Ilashku case prior to May 2001 in order to secure the applicant's convention rights. They included interventions by Moldovan politicians condemning the illegality of the applicant's detention, judicial measures taken against those responsible, sending doctors to examine them and providing financial assistance to their families, and the Minister of Justice negotiating for their release. In the Ivantoc judgment, also about Transnistria, Moldova was found to have met its positive obligations by constantly and systematically raising the applicant's particular situation and by continually seeking the assistance of other states and international organisations to secure their release. In this case, the extent of the positive obligations on the state should be assessed in the light of, firstly, international law, notably the Pinheiro Principles, and secondly, specific steps stipulated by the international community in the particular context of this dispute, and thirdly, international practice, as for example in the Dayton process. First and foremost, this means ensuring the right to return and restitution, but it also means ensuring a right to compensation. And there are also many other preparatory steps which should be taken leading to return or compensation. They include establishing a legal regime to verify property ownership, establishing an independent institution to assess and enforce property claims. Other confidence building measures are set out, for example, in Annex 7 to Dayton, and even phased returns in zones which are demilitarised and supported by an international peacekeeping force. At no stage in these proceedings has the government ever suggested that it has sought to achieve such aims or anything remotely comparable. The position of Azerbaijan in this case presents a stark contrast to the considerable efforts made by Moldova to reassert the applicant's convention rights in Ilashku. We submit that the government's jurisdiction and responsibility is therefore clearly engaged in this case. Mr. President, I turn to the merits. The government has sought to deny that Mr. Sargsyan was the owner of any property in Gulistan, and they do not accept that